All right, everybody, we might get into our webinar for the day. Good morning, good afternoon, depending on where you are dialing in from, and welcome to Mapien's annual Year in Review webinar. I'm Jamie Patterson. I'm the Mapien's Head of Workplace Strategy for Southern Region, and I've got Jessica Bernardo here, our consultant in our Melbourne team, who's assisting with administrating and running the webinar for me today. So Jessica is going to be my first port of call if anything happens from a tech perspective, which hopefully it won't. Before we start, a couple of quick admin points, if I can, please. We're recording this webinar, so you might have heard that when this started. That will become available on our website over the next few days. As we work through this today, if you have any questions, I encourage you to please drop them in the Q&A box in the webinar portal. And any questions that we don't get to, we'll try to address some questions throughout, but any questions we don't get to today, we'll pull together in a Q&A document and we'll send that out to you, to attendees over the next few days. So the past year has largely been about embedding and testing newish legislation that has come into play over the last few years. And this has resulted in some interesting case law that as employers have tried to find their feet and navigate their way through a system that's becoming more and more complex. To add to this, psychosocial safety and associated legislation has provided additional challenges for employers, exacerbated by the fact that it's state-based legislation which is coming in at different times throughout the period that it's being implemented. So while there has been a fair bit of interesting employment and workplace challenges take place, today we want to pull it all together and provide an overview to the attendees of key aspects and key lessons that we've seen. And to do that, we've got three Mapien experts joining us very much from a national perspective. We're based in Melbourne, Brisbane, Sydney and Perth today. And I'll run through some quick introductions. So we have Matt Griffiths, who's Mapien's Head of Industrial Relations for Western Australia, and Matt will be talking to us shortly about the year in review from an industrial relations perspective. We have Damien Power, who's Mapien's Head of Workplace Strategy for New South Wales, and Damien will be talking to us about the year that has been from a HR and workplace strategy perspective. And we have Dr. Leith Middleton, Mapien's Specialist Group Lead, Psychological Health and Safety National, and Leith will be taking us through the year that's been from a psychosocial safety perspective. So from here, I'm going to hand straight over to Matt Griffith, who will take us through the year in review from an IR perspective. Matt.
Thanks, Jamie. First of all, as Jamie's just mentioned, thanks everyone for jumping on this call. So I've joined Mapien recently as a head of IR in WA, and I've been playing in the IR world for probably 30 years. This morning, I was excited to be given this opportunity to talk about IR, but I also wanted to reflect on how I deliver this. So what I do recognise is on this call, there are a range of different people with experiences, skills, interests. I'm talking IR to some people on this call who I believe are excited, invigorated, and enjoy the opportunity to cleanse their soul talking about IR. On the other hand, I know there's people on this call that probably find the IR world frustrating, dull, and probably resembles something in line of a horrible tasting cough medicine you've got to take in certain times of your corporate life. So I want to deliver today's session, appreciating the call and the diversity, and really provide a broad discussion on a number of areas of legislation in a pragmatic way that's sympathetic to all on the call. And what my intention is to create an opportunity for further discussion around particular areas of this presentation and more broader IR interests afterwards through either question and answers, or if you want to reach out and have a more detailed conversation, please feel free. The first part of my discussions, I really want to look at the legislation. There's been a number of changes that we've seen occur over the preceding 12 to 18 months. I'm going to deal with two smokies, as I call them. So the union right of entry, there was an amendment to the right of entry provisions, which provided permit holders the ability to access work sites without notice if they believe there's a contravention of underpayments. And this is done through an exemption application at the Commission. This was at the time quite a concerning amendment to employers. We all enjoy a good right of entry and a good union attendance. So the idea of them turning up unexpected was something that didn't excite many employers. However, what we do see is there's been no applications for this from permit holders. So it was a bit of a smoky and didn't really get traction. The right to disconnect, another one that got very excited. The Modern Awards got amended. Employers started looking at it in terms of their bargaining obligations, and I'm seeing in some EAs this appearing. Again, this hasn't bitten. In the last financial year, there were 7 applications for issues around right to disconnect. The intent and the outcome are certainly a long way apart. What I can say though is in August of this year, the legislation will now apply to small business. So if you are a small business, please make note of your obligations under this part of the legislation. Bargaining disputes, they're again incredibly enjoyable whilst you're trying to do a deal with the unions. The introduction of intractable bargaining was again a really hot topic at the time. What it did was bring the Commission into play to resolve through arbitration disputes. Talking to my union friends, they were concerned at the time that this would be weaponized by employers and not used for the intentions that they were brought in for. So the intention at the time was to provide a strong incentive for good faith bargaining negotiations, reduce the time for enterprise agreements to be finalised, and allow for quicker resolution of disputes. Ultimately, the amendments were intended to get wages moving and not to find an opportunity for certain employers to game the system and find ways to get conditions to go backwards. What we are seeing is probably a blended version of that. So the unions don't like it because employers now won't necessarily put an active effort into bargaining whilst there's an interim EA, and they will use the intractable bargaining dispute mechanism to deal with certain issues. So it's putting pressure on the unions now as well to then stay out of this arena because they don't want their major issues determined by the Commission either. So it's certainly something as an employer to consider in your bargaining tactics. And we're seeing it recently up north in the offshore with some recent bargaining where it was used as a mechanism to try and create a diversion in bargaining. Multi-employer bargaining. There was a spike last year with their applications for multi-employer bargaining. The intent of this has so far landed. So it's hitting industries and sectors with low wages and fragmented agreements. So childcare, aged care, in particular in retail, we're seeing an interest. I recently hosted a industry roundtable with the shipbuilding and AUKUS sector, which is going to be a huge sector nationally, particularly in WA with maritime defence, building of ships and submarines. This is done nationally, and in that discussion, what we determined was there's going to be a real push for multi-employer bargaining in precincts. This will hit defence productivity and outcomes, and there's certainly a higher risk for sectors that are going to be reliant on multiple employers to support delivery. So that's a higher risk, and I'll watch this space. Enterprise agreement making, high alert. This one's been a real challenge over the last 12 to 18 months. For those of you aware, there's the Fair Work Act, and then there's the genuine principles. The genuine interest principles. These are two components that are factored into determining the approval of an EA. Currently, there are over 4,000 applications passing through the Commission for single employer-based agreements. And then on the back of that, what we're seeing now is a 100% increase, or a 100% increase of agreements being withdrawn from the Commission's application process. The reason for that is the unions are using the general interest principles and the Fair Work Act to appeal agreements at the approval stage. This has been a significant increase in employers now finding it more difficult to do an EA which doesn't have a union attached to it. The current processing of agreements, there's about 75% agreements are unions and 25% are non-union. That's been pretty consistent, but through the general interest principles and the other amendments, the scope of the EAs has increased, and the coverage of employees attached to EAs has increased significantly by 35% quarter on quarter in the last 12 months. When I go back to the genuine interest principles, and we'll talk about it more later on, it's really important for employers, particularly if you have the luxury of having a direct agreement with your employees, to protect that and maintain that. And that needs to be really well thought through. The casual conversion and the definition of what a casual is, that's the employee choice legislation, which is the pathway for employees to seek either full-time or part-time permanent work. There's been 44 applications that are attached to this recently, over the last 12 months, where employees have escalated at the Commission for compulsory arbitration, which is their right. This one's a watch this space section, because I think this is going to continue to grow as employees understand or appreciate they have a right to convert, and there's limited opportunities for employers to object. Small businesses now have the enjoyment of having this now being a provision in their operations once an employee passes 12 months employment. So for small businesses, this is a real compliance challenge that needs to be really considered. The other component that we're seeing is union rules. So in the industrial world, we have the union rules, which is what a union can and can't do, and there's demarcation issues. The union rules are really important when we go into bargaining or we have disputes or issues. What I'm really encouraging employers to educate themselves on, if they aren't, is understanding the union rules more. What we're seeing from unions in the current landscape is they believe they can do anything, and they'll make a shirt up which says it, and then they'll walk into your site and say, well, I've got a shirt that says I do this, so I do this. We need to be, as a business group, understanding the unions and their roles and what their members are. One of the areas I've seen clients getting caught on is a union saying, I have members. Members are determined based on their rules. So they can have a member, they can have someone signed up to the union, but they're not a member by definition if the rules don't cover them. So again, I do strongly advise that you're appreciative of this component as you go into bargaining and even managing things like right of entries. I'll move on to a couple of cases that we've seen. So very quickly, we've heard about the Woolworths case. We've seen a lot of discussion around that. I've had clients ask me, well, what do I need to do? The Woolworths case really looked at rolled up salaries for employees covered by the award on pay cycles, ensuring that each pay cycle doesn't breach the award provisions. As a business, this is a watch this space, but I think at a minimum, we need to be just thinking about our own compliance obligations and ensuring that our employees, including us, our managers who may be operating under the award, are appropriately remunerated for roster patterns. That can be quite a simple, pragmatic approach to running rosters to your managers and determining what is the threshold for satisfying the award. And where you are sailing close to the wind, you'll need to talk and consider more how you manage that risk. The other part of it is, how do you record the roster patterns they work. So the additional overtime and if there's any shift penalties, etc., that they're working, is making sure that that's appropriately captured in case there's an audit and you need to demonstrate. Again, watch this space. My understanding is it's still under appeal. The case that Qantas recently received around the outsourcing, I think is a real take notice for employers. So that case was in effect during COVID when Qantas outsourced a section of their workforce. The rationale for the outsourcing was 90%, acceptable, but where the issue fell over was through the discoverable of documents, the commission and the unions became aware that a part of the decision making for outsourcing was to mitigate the need to bargain with that workforce. So that created a general protections claim times by, I think it was 1,800 people, which created a significant penalty for Qantas. Qantas already paid 120 million to the outsourced employees, but now wore a $90 million penalty. That penalty also reflected the court's view that the employer of that size and stature should have been more, ethical and considerate to the employees, because their response post was probably nothing short of really concerning in terms of the impact to employees. So the court found $50 million of that payment should go to the union to ensure they have a fighting fund to take on future employers that are breaching or are seen to be breaching the Act. That's a real strong statement from the judicial arm of IR. The other 40 million is sitting in a trust fund, and they're going to determine whether it goes to the impacted employees or continue to fund unions to take on employers. BHP, and can I just also say, I think there's some BHP people on this call, so I want to shout out to the organisation that you put up a good argument and you really pushed the envelope on the Commission's role in applying the orders. The regulated labour hire arrangement order that was issued to BHP was a real eye-opener. So when that legislation was introduced, it was around making sure that if you're contracting out labour, you have to match the employer's head rates. But there are exemptions in it around providing a service, and BHP put up a strong argument around the service offering as opposed to contracting out. The Commission found against that argument, and there's a number of areas which I'm happy to talk about after this call to those that are interested. But as an employer, I would strongly advise that you review your contracting arrangements to ensure that this isn't going to be an issue for you. We're seeing it in the offshore. We've got clients up north who are experiencing the same issues. And we've seen in the last 12 months, there's been over 130 applications for these orders to be sought. So it's certainly going to be a watch this space, and probably it's a Labor pet legislation. So unfortunately, with Labor being so indoctrinated into the system right now, this won't go away. I'm going to touch on the actually, I might just, due to time, I'm going to touch on the Fair Work Commission's performance. So last year, the Commission saw unfair dismissals steady at 37%, so 16,500 of them. General protections came in at 14%, and that was an increase. Justice Thatcher's and employer associations are talking about the general protections legislation now and really trying to challenge the access and applicability of this to employee claims. The Commission's been flooded by them, and they're not resourced up to handle them. They're finding a lot of the claims coming through are frivolous or not genuine and are merely chasing settlements. So the type of thresholds they're looking at are increasing application fees, and even possibly looking at the threshold for unfair dismissals to try and divert back into that channel. Interestingly, the other increase that I saw through the commission was a significant increase in sexual harassment disputes. So under the Fair Work Act, sexual harassment provisions were put in place to enable the commission to intervene. They can provide orders to stop and deal with it, to stop it or deal with it. So the stop and deal orders were significantly increased. And I'm wondering whether this is coming back through more broader education of companies around sexual harassment and the internal mechanisms for managing it, given they're going out into the commission seeking resolutions. And finally, I'll just talk to quickly terminating agreements. Over the years, terminating agreements has been quite a popular discussion in IR tactics. In 2020, there were over 300 applications, and it was quite a sensible way of putting pressure on unions. What we've seen now, that has been significantly reduced through the legislation. We're nearing maybe 100 applications, and only a handful are getting through. So employers are moving away from this tactic and certainly not seeing success as they would like. So in finally summing up my IR chat, I think we need to recognise probably in the last 40 years, the current industrial landscape is heavily Labor-led and Labor-lent from federal state. We're seeing the magistrate courts stacked with ex-unionists. We're seeing the Fair Work Commission balancing the table, so to speak, with a lot of Labor-friendly commissioners. And we have an industrial relations machine that employers are sticking their hands in and not having them come back. So industrial tactics need to be really thought through sensibly, with a lot more consideration to those broader issues I spoke about. Not that it can't be done, but it just needs to be thought through a lot more. Thanks, Jamie.
Thanks, Matt. Some really good insights there. The changes in the industrial relations system have definitely had probably the desired result, which is increase in the number of agreements and the increase and strengthening of union involvement in the relationships. So some good messaging there. We have got some questions here, but in the interest of time, I might pass straight on to Damien Power and get Damien to take us through the year in review from a HR and workplace strategy perspective, and we can circle back to questions later if we've got the time.
Okay, thanks, Jamie, and thanks, Matt. Pleasure to be with all of you today, and thanks for the opportunity just to give you an update on some of the things that we're seeing in the HR space. So I've got three pretty diverse topics that I wanted to update you on and share some reflections on. And the first one's really around restructuring and consultation. As you know, a lot of businesses are under a lot of financial pressure at the moment. There was an uptick in unemployment to 4.5% in September. You've got the impact of AI starting to flow through to various businesses. And all of this seems to be reflected in a number of reports that are coming out, particularly say one from ARI, which looked at redundancy intentions. And there's a rising tide or an increasing percentage of companies that are looking at redundancy and restructuring intentions in 2026. So given all of that, I wanted to share with you two really quite different cases from different jurisdictions, which really focus on the concept of restructuring, redundancy and consultation. The first one of those comes through from the Fair Work Commission and it's a case of Sarah Wilson versus Brisbane Crane Trucks. And this particular unfair dismissal claim dealt with a customer service officer who was made redundant. In short, the employee said that the employer had not followed the consultation processes that they were required to follow under the Clark's Award. She alleged she was given no prior notice of the redundancy proposal and no real genuine opportunity to provide suggestions or to ask questions. Now, the interesting thing about the ruling from the Fair Work Commission in this case was that the Fair Work Commission actually accepted that there were genuine changes in operational requirements, And these operational changes did legitimise or support the case to downsize the business and make staff redundant. But interestingly, it also found that the way the company went about the consultation process, they'd failed to comply with the award. And for that reason alone, they found that the redundancy was non-genuine. In in working out the appropriate remedy, obviously reinstatement wasn't considered, but compensation was awarded. But the amount of compensation is really quite curious, because the amount of compensation that was deemed appropriate was 2 weeks' pay, and that was the time frame which the commission determined the employee would have remained employed for if proper consultation processes were followed. So the second case I want to deal with comes from a really different jurisdiction, and it's quite a novel case, and it involves SafeWork New South Wales, who are the New South Wales safety regulator, and the University of Technology in Sydney. Now, as some of you may know, SafeWork issued a prohibition notice on the 2nd of September to UTS, ordering them to pause the job cuts flowing from the restructure process. And that was because they believed that the restructure and the way it was being managed posed a serious and imminent risk of psychological harm to the employees' mental health. Now, in the lead up to that prohibition notice, staff at UTS had actually contacted SafeWork, and SafeWork had made inquiries and investigations. And the nature of the feedback from the employees was that there were very poor consultation processes in place. Staff were being invited for the restructure meetings with very late notice. The language that was used in the documents regarding the restructure was quite finalistic. And so it was, given that it was came across as a fait accompli, all of this really produced a culture of fear and really heightened their job security. The UTS scrambled and got some things in order, and got some, I suppose, responded to the SafeWork notice, and the prohibition order was lifted on the 5th of September. But I think what these two cases demonstrate is that regulators will involve themselves in restructures if they believe there's poor consultation or poor process management, particularly where they perceive there to be a risk to the psychological health and safety of employees. So for all of you as employers, a couple of the key takeaways from these two cases are: it's really important that you understand the consultation and significant change clauses in your awards and EAs, that you genuinely consult with your employees once you've made that decision to proceed with a proposed change, that you share information with the employees and the expected impact. It's really important to give your employees appropriate timeframes to consider the information that you're providing regarding the restructure, and that you give them the chance to come up with suggestions, alternatives, and questions. It's also important that when employees do provide you with alternatives and suggestions, that you genuinely and properly evaluate that feedback and you communicate your views or the outcomes of your deliberations in writing. And from the psychosocial perspective, and I don't want to tread on Leith's toes too much, but it's really important that you've got good mechanisms in place in terms of EAP, points of contact for questions, that you communicate in a really respectful way, and that there are channels where employees can direct their concerns and complaints so they can be addressed in a timely fashion. And finally, I think it's really important that with these type of restructures, there's a bit of proactivity that's required. If it's likely that they're going to be hazards, and there's foreseeable psychosocial risks associated with the restructure, it's really important that the organisation conducts some kind of psychosocial risk assessments to ensure that they're putting in place some controls to minimise the risks that are being faced. So I think, in short, these two cases really demonstrate that employers need to consider not only the IR and the ER aspects of restructures, but also the psychosocial aspects. So I'm going to change tact quite a bit. I just wanted to give you an update on a compliance obligation, which I think will drive many of you nuts. It's the payday super legislation, which was recently introduced. As a concept, it was first mooted or raised back in the 23-24 federal budget. And with the legislation that was recently introduced to the House of Reps, it's due to take effect now on the 1st of July 2026. And I think the expectation that it will come in from the 1st of July 2026 was heightened when the ATO simultaneously released its practical compliance guidelines. So if you haven't heard too much about it, I'll just give you an overview of some of the key aspects of the laws regarding payday super. Superannuation from the 1st of July 2026 will need to be remitted to employee accounts within 7 business days of payday. Under the original legislation, it was 7 calendar days. So fortunately, that's been stretched out to 7 business days. One of the concepts that many of you would be familiar with for many, many years, in fact, maybe decades, if you've been administering superannuation for that long, is that we're moving away from quarterly contribution limits to an annual maximum contribution, which means rather than paying up to a certain amount each quarter, then ceasing payments, now you keep paying continuously until you hit the annual maximum contributions cap, and then you cease paying for the balance of the year. Ordinary time earnings, which is a concept many of you would be familiar with, is going to be replaced with a fairly similar concept of qualifying earnings. Quite concerningly for employers, any under contribution or late contribution is going to result in employers needing to pay interest. It's yet to be determined how that's going to be implemented or administered or enforced, but that's a significant one that provides an impetus for employers to make sure they get on top of this legislative change. And finally, there will be quite a range of technology changes to single touch payroll and SuperStream reporting to accommodate payday super. So from our perspective, in terms of what we'd be suggesting that you focus on over the next 6 to 7 months, obviously you need to get your payroll system up to date and make sure that the configuration of your payroll system can accommodate payday super. Secondly, you're going to need to update your reporting mechanisms or your Excel spreadsheets if you use those to make sure that you are able to report on year-to-date super contributions. Probably one for the finance people, you're going to have to think about the cash flow impacts of moving from quarterly contributions, if that's how you've made your contributions in the past, to making payday super contributions, which is either on a weekly, fortnightly, or monthly basis, depending on your payroll cycle. And finally, and this is one that probably you need to get on pretty quickly, super funds under the legislation need to remit super to employee funds within 3 days. And obviously you'll remit your super to your clearinghouse on the payday, but you're going to need to have a look at your service level agreement with your super clearinghouse to make sure that they are processing where the super needs to go to in terms of all the different super funds that your employees are members of, to make sure it gets into the account within 7 days. So check your service level agreement, because at the end of the day, if the super clearinghouse is slow in getting the funds to the superannuation company, it's not going to be them that's in difficulty, it's going to be yourselves, unless you've got a service level agreement which reflects the timeframes that they need to act within. So I'm going to change tact quite a bit once again. I thought it'd be interesting just to reflect on what's happening with diversity, equity and inclusion from a HR perspective. Obviously, we've all heard about some of the Trump decisions in the US, given his election, and what that's meant for federal employment practices in the US. And obviously with federal employees, there's an order now that they don't have to consider diversity, equity, inclusion in their employment practices. And this has also had a bit of an impact or flow-on effect to some of the private sector companies in the US, with a number of them saying they're going to be ceasing their affirmative action campaigns. What's quite interesting is that Australia is quite different. It would be true to say that some companies perhaps have gone a little bit quieter on the DEI front, but overall, the response that we've observed from corporate Australia is that the trends in Australia and the response to what's happening in the US in Australia has been pretty minimal. And I think on reflection, this has really been driven by 2 things. I think the first is the respect at work and positive duty laws, which came in a couple of years ago. And the second is obviously the mandatory reporting obligations for employers who have more than 100 employees, which are, with reports due to the Workplace Gender Equality Agency. So if there is to be any impact of US developments, we won't really know about it, probably for maybe several years. But it was really interesting to see some of the results from the 2023-24 WGEA report, which came out in November of last year, because it does tell us a little bit about the direction that Australia's been heading in and where we might go in the future. And I thought it might be worthwhile just sharing a few statistics from that report. In the 10 years to 23-24, the gender pay gap for average total remuneration fell from 29.2% down to 21.5%. But probably even more significantly were some of the program and policy development trends in the last 12 months. So for the 12 months to 23-24 for the reporting companies. And some of these percentage increases are really quite significant. The first one was a 13% increase in employers undertaking a gender pay gap, up from 55 to 68%. An 8% increase in employers with a formal policy that was designed to support employees who have family and caring responsibilities. A 6% increase in employers with a formal policy to support employees experiencing family or domestic violence. And a 5% increase amongst those employers offering paid parental leave in addition to the government paid parental leave scheme. So the 24-25 WGA report will be coming out very soon. I think it's maybe due out in late November. So it'll be interesting to see how these trends evolve. But it's not just what's happening in DEI isn't just limited to the WGA space. There's other things happening in other areas, and one of those areas is with the Fair Work Commission. As some of you may know, there have been a series of gender undervaluation cases in female-dominated industries. And for those that don't know, there's already been award rate increases and role classifications in the pharmacy award, which came into effect from the 30th of June. And there were also recently Fair Work Commission expert panel hearings where they were getting submissions just in October and November on gender-based undervaluations for the Health Professional and Support Services Award, for the SHADS Award, and for the Children's Services Award. So in summary, I'd suggest that DEI is probably going to get more attention and not less attention in Australia in 2026, regardless of what's happening in terms of global trends and global directions. So there's three pretty different topics, and I'll hand back to Jamie and hand over to Leith.
Thanks, Damien. While we've got you, I've got one question here that reverts back to, I think it's the superannuation. So are there any exceptions to employers making payments within 7 business days?
Yep. Okay. So the exceptions are for new employees. So if you've got a new employee, their payday, their first payday super won't fall within the first 2 weeks, even if there is a payday in the first 2 weeks. Their first, the first contribution for their payday super will be the first or the next payday after the first 2 weeks of employment. And the other exception is for out-of-cycle payments. So if you have out-of-cycle payments for, say, bonuses or back payments, there won't be a payday event on that out-of-cycle payment. That the super that needs to be contributed for that out-of-cycle payment will move forward to the next regular payday event. Yep.
Okay, great. Thanks, Damien. All right, I might hand over to Dr. Leith Middleton, who's going to take us through her year in review from a psychosocial safety perspective. Leith, over to you.
Thanks, Jamie. Hi, everybody. The things that I'm thinking of talking about just in my section today are really just some reflections, some of the key reflections from 2025. But also one of the key things I get asked by clients is what are other workplaces doing in this space? Because it is such an uncharted territory. So I'll touch on that a bit as well. I also want to touch on, and I think what Damien's been talking about there around process and consultation is sort of really, I guess, relevant to some of the things I was going to talk about as well, in terms of just this increasing focus around the hazard of organisational justice, and workplaces really needing to think about the process under which they undertake things. And also just a few top tips, I guess, for workplaces to consider. So I know I've met some of you before, and there's folks on here who've probably been to some of these webinars before. But just to give a little bit about my background, I think psychosocial safety is a little bit of an unusual one to be in at the moment. But I'm a psychologist by profession, but there's probably a few things about my background that have led me into this area. A bit of a combination around sort of organizational psychology, which is probably mostly where I've done my work. But also, I've done quite a bit of clinical work in GP practices, just seeing clients in the past. And I think really getting to see the impacts on individuals that workplace challenges and hazards do have on them. And also, I think one of the things where I really got to see a bit of a generational shift was in some work that I was doing at UQ in the medical faculty. And we were implementing sort of medical support strategy for medical students. And that really opened my eyes to, I guess, some of the things that younger professionals are now being exposed to and their expectations around mental health in the workplace. And I think we're seeing a real shift in that at the moment, which is contributing to this area. So in terms of just some of my psychosocial safety reflections from this year, there's obviously been a lot of change and progress in this space. And we really have gone from people just being completely oblivious to this to, I'd say, pretty much every workplace that I interact with now, they're doing something in this space. And there's a bit of a continuum there around people doing a lot and some people just kind of doing smaller aspects of that. But I think generally workplaces are driven by the compliance side of this, but also on an interest in mental health and around wanting to create mentally healthy workplaces for folks. And I think what we're really seeing is regulators are really ramping up in this area as well. And I think that's really obvious and they're signaling that quite strongly. So I think it'll come a time where it'll be difficult for workplaces to say that they haven't seen this coming. For example, I saw that SafeWork New South Wales reported that inspectors had carried out 228 psychosocial checks recently, speaking with employers and workers about things like stress, harassment, and other psychosocial risks. So we can see that a lot of the regulators are still in an awareness building and educational space, but clearly signaling that this is really front and center for the regulators. And we're also seeing that the appointment of psychosocial specific inspectors that we haven't seen before as well. So I think we're going to see a lot of change in this area around compliance. Something that we've been seeing quite a bit more recently is an uptick in psychosocial PIN notices. So for anyone maybe not from a workplace health and safety background, this is where there might be a performance improvement notice issued to a workplace. And we've been supporting organisations who are receiving these PIN notices, but really not knowing what to do or how to clear their PIN. Most of these have been in the conduct space so far, but I think we're going to see more of those. And I think, Damien's talked about the organisational change area, and I think we're going to see a lot more where there's PIN notices or complaints going to the regulator from employees or groups of employees. And if the regulator feels there's enough information and evidence to kind of go and visit that organisation, they will conduct an inspection and then potentially require organisations like yourselves to undertake some things in a time-framed way as well. I think that's really important as well, to be able to clear that PIN. Yeah, and look, one thing we worked on recently with an organisation is where there was a complaint to the regulator around a conduct matter or sort of bullying and harassment that the person felt like hadn't been dealt with by the organisation, and so there was a PIN notice issued to that organisation. I think what was really interesting in this particular scenario is that the subsequent work that we did with them did actually unearth quite serious allegations of sexual harassment and potentially even sexual assault. And for me, this was actually a really sort of a positive reflection that this regulator activity is helping to unearth very serious conduct that may not have been unearthed through other means. And I think that was a real positive for me, because I think sometimes people are seeing the compliance and the regulation as like a difficult thing or a challenging thing. But on this case, the organisation potentially would not have found out about this situation had the regulator not issued the PIN notice and further investigations happened. So what have workplaces been doing in this space? I think that it's been quite varied in terms of what they've been doing. So I thought I'd just reflect on probably a few themes I've noticed across workplaces. Firstly, there's been a lot of internal efforts to build capability in psychosocial safety. So, training and development is very common in this space, right up to the board level. I'd say that we've been doing a lot of board level awareness sessions to try to just give boards a little bit of an understanding in this space. I think staff in general and leadership as well, just a lot more training and development in this area to build capability. I think one area I probably haven't seen a lot of, where I think is really needed, and you might want to consider this in your workplaces, is a bit more concerted effort to build capability in HR and safety teams. I think what I've noticed is there's a bit of an assumption that HR and safety teams know what they're doing in this space, or will naturally be able to add this to their agenda of what they do in terms of business as usual. But I think what's really important to know is this is not a traditional part of safety or HR training. Like psychosocial is really like quite a new concept, or the expectations are a lot higher for HR teams and safety teams to really understand mental health. And so that's certainly one area I'd say, we'd like to see a bit more activity in organisations because it's quite a specialised area of capability and knowledge. Another theme that I've noticed is a lot of workplaces are interested in the codes of practice and how they may align their activities with this. And probably one of the key things we're doing with organisations at the moment is psychosocial audits. And when I say psychosocial audit, I do not mean psychosocial risk assessment. I mean an audit, like against the code of practice. What are we doing? What does our organisation have in place? And a key question I get asked a lot is around how do we know if we're compliant? So there's a lot of use about this word. How do we know if we're compliant? How do we reassure our boards and our senior executives that we have compliance in this space? Probably this is something I've talked to a lot of workplaces about and have thought a lot about this year. But I think the difficulty is that while the codes of practice for the states that do have these do give quite specific guidance, they're never going to exactly tell you, like it's not going to be a recipe on exactly how you implement this within your organizations. So there always is going to be some onus on the organization to determine, okay, here's the code of practice. What have we got in place? Where are our gaps? And what are our sort of, how does this fit with our safe system of work, and what's reasonably practicable in this space as well? So there's always going to be some onus, I guess, on your organizations to kind of determine that based on, I guess, all sorts of things like the size of your workplace, what kinds of infrastructure you've got, what, the profile of your workforce. So the other thing that I'm seeing a lot of is workplaces conducting psychosocial risk assessments and trying to embed psychosocial safety in that respect. And I think that's been really positive to see workplaces really have a go at that. One of the challenges in psychosocial that I've noticed is really this idea of severity, duration, and frequency, which is a requirement under the legislation and the code, but doing that for psychosocial is quite challenging for organizations. So I think that's something that a lot of workplaces are really working through as well. Um, Probably the other area I want to comment on that is a lot of organizations are still doing psychosocial risk assessments by hazard. So they're like organizational change, role clarity, bullying and harassment. Really, where workplaces need to start considering is the interplay of hazards and the fact that it's usually the interplay of hazards or the cumulative impact of hazards that is going to potentially lead to harm. And so I think there's a maturity lens for psychosocial assessments around that as well. Just a couple of comments about, carrying on, I think, from what Damien already talked about around consultation and around process. And I think this really shows, and it's great to have Damien talking about that, because I think what this really shows is that natural collision now between HR and psychosocial safety, and the fact that these things really can't be separated anymore, and that people do need to be taking a multidisciplinary lens to this. And most of the things that we're seeing is a greater expectation in the process of how things are done at work. And this to me relates to the psychosocial hazard of organizational justice. We're seeing this come up in fair work outcomes. We're seeing it come up in complaints. We're seeing it come up in investigations and also complaints to the regulator as well. So, for example, performance conversations and mental health issues. This is a really complex area at the moment. And probably, even up until a few years ago, most managers were primarily concerned about reasonable management action in this space. So are we, conducting these with reasonable management action? But now what we're seeing is this need to almost do psychosocial risk assessments on the process as well, and to consider the hazards that might be impacting people when we're doing performance conversations with people or undertaking performance. I think there's a bit too much emphasis in the media at the moment about are employees weaponizing mental health, and trying to kind of take it from that angle. I'd probably encourage organizations just to kind of push the noise of, are employees weaponizing this out a little bit, and just think a bit more about, are you running processes? Are you doing fair, is your reasonable management action in place? But also, are we doing appropriate psychosocial hazard assessments or risk assessments when we're undertaking these as well? This also relates to workplace investigations. So this is something where I must say there is a lot of activity around. There's always been policies, procedures, and legislative requirements, but really from a process perspective, we're starting to see the need to run psychosocial risk assessments on investigation processes, upskill investigators in psychosocially informed investigations. And to me, that's more than trauma informed. It's actually, are we doing appropriate psychosocial risk assessments? Are we embedding psychosocial into the process of our investigations? And I think we're going to see a lot more in that space now. So I'm just conscious of time. So I just wanted to quickly flag my top tips though, for people to consider in 2026. It still remains taking a strategic approach to psychosocial, moving from less scattergun approach. We've got EAP, we've got resilience training, but to more a cannonball approach. So either doing audits, psychosocial frameworks, things like that are going to guide the organization and give your boards an understanding of what strategically is happening in this space. Building the capability of your HR and safety teams, and And probably one of the biggest things I wanted to comment on that I haven't seen done well at all yet is board reporting in the space of psychosocial. This is something that really needs a lot of work in organisations, as ultimately they are going to be the officers ultimately responsible for this area, as they are with other areas of safety. So that's probably a little bit of a summary from me, and just throwing back to you, Jamie.
Thanks, Leith. That's a really great summary. It's certainly an area of employment that is has and will continue to get a lot of focus. So it's really important that employers across it. We got 5 minutes left. We've got a couple of questions here. Leith, I'm going to put you on the spot and throw one at you. You talked about upskilling. You talked about training in this area. The question is, if your workplace was to invest time into psychosocial training, when would you suggest to get the best bang for the buck?
Yeah, okay. So I think, and I think training is still important in this space. Like, so in psychosocial, we really still want to take a systems approach, and training is just part of that system. And I think if I think about the kind of feedback we get from clients about the training that helps them, that's what sort of is starting to inform me in this space about where organizations can get the biggest bang for their buck. Probably one of the biggest areas in this space is really around, and probably feeding on from what I was talking before, psychosocially informed investigations training for workplace investigators. So this is going to be a huge area, I think, where investigators are going to need to know how to run processes in a psychosocially informed way. Performance conversations and mental health is a really big area that needs to be looked at from both a HR perspective and also a psychosocial or a psychology perspective. And also, I think just respectful workplaces training as well, where we can really help to upskill people, I guess, in that, just more broadly, to get people knowing how to contribute from being a staff member, but also a leader.
Okay, thanks, Leith. And Damien, I'm going to quickly throw to you if I can. We've got a question here. We've got about 3 minutes to close out. So what other DEI changes, asking you to look into your crystal ball here, what other DEI changes are likely to be pursued by the government in 2026?
Apart from those that I've already mentioned, there was a recent government initiative from the 9th of October this year when they introduced a new bill, and it relates to employers, or it prevents employers from cancelling paid parental leave for parents who experience stillbirth or a neonatal death. Some of you may have heard or seen the well-publicised media case regarding baby Priya. So it's become known as baby Priya's bill. So that hasn't yet passed, hasn't yet become law, but it's expected to. Another one that's maybe a bit further down the track, it might be 6, 12, 18 months, 2 years away, it's hard to really tell, is some legislation that the Greens introduced regarding reproductive health leave. They're proposing 12 days of paid leave for reproductive health. So it has been introduced by the Greens into the House, into the Senate. It has been, it does have the backing of the ACTU. The government hasn't said anything about that particular initiative or that particular piece of legislation. But it wasn't that long ago that the Greens put up right to disconnect legislation, and before anyone knew it, it had come through. So that's one to keep an eye on. It may be quite a while off, but it's a possibility that might get up at some point.
All right, good. Thank you, Damien. Look, we've literally got 1 minute to go. We haven't got to all the questions that we've got here, but as I said at the start, we'll collate those questions and pull together a Q&A document and send that out to attendees over the next few days. I want to thank our presenters for your insights and information that you provided today. Thank you, Jessica, for running the webinar in the background and pulling all the questions through that that we've got. That completes the webinar for this year. We tend to run these twice a year to align with the calendar year and to align with the financial year. So keep an eye out on those on our website and come along. One final plug, we are running our Balancing Performance Conversations and Mental Health day-long training sessions. We're running one in Brisbane on the 12th of February. Perth, we're meant to be running one. I think it's being scheduled into February, and we're running them in Melbourne and Newcastle as well in March 2026. Exact dates are to be advised, but please keep an eye on our website. Other than that, thank you all for attending, and have a good day from here.